The High Court dismissed an integrity case against Jubilee presidential candidate Uhuru Kenyatta and his running mate William Ruto, clearing the way for them to seek votes from Kenyans in next month's general election. The court said it has no jurisdiction to rule on the eligibility of the Jubilee team. A 5-judge bench sitting at the Milimani courts delivered the landmark judgment this afternoon, clearing the final hurdle for the two before next month's election. The judges ruled that only the Supreme Court can make the determination. The court says stopping the two from vying for the political seats will be denying them their democratic right, which is guarded by the Constitution.
Article 50 of the Constitution, the third and fourth respondents are to be presumed innocent until the contrary is proved. The entrenchment of this article is meant to ensure a fair trial in respect of every person before a court, tribunal, or body. This right falls under the category of fundamental rights and freedoms that may not be limited as provided in Article 25 of the Constitution. We have already placed on record the rights of the citizens of this country to make political choices, and indeed the rights of the third and fourth respondents to seek public office. Article 1 of the Constitution of Kenya places the all sovereign power on the people of Kenya, which shall be exercised only in accordance with the Constitution. It shall not be and can never be the role of this court to exercise that power on behalf of the people of Kenya. That right must remain their best possession in a democratic society and is inalienable.
The integrity suit was filed by 4 NGOs which had wanted the High Court to rule if the two can still vie for high office with crimes against humanity charges pending at The Hague. The ruling follows yesterday's status conference at the International Criminal Court at The Hague, in which they participated via video links from Nairobi.
Is that the confirmation of the charges against them at the ICC would be a threat to the Constitution. Further, that the presumption of innocence in their favor should not override or outweigh the overwhelming public interest to protect and uphold tenets and principles of the Constitution as set out under Articles 10 and 73 of the Constitution.
One of the NGOs has vowed to move to the Supreme Court with the same matter. Uhuru's main challenger, Raila Odinga, says he is happy with the ruling because it ensures that his competitor remains on the ballot paper. The National Alliance Party Secretary General Onyango Olo says he is happy that the court has respected the democratic and human rights of Uhuru and Ruto.
The first time in the history of the Republic of Kenya, we are pleased to note that the courts have stood strong and tall for the people of Kenya and have come clear that there will never ever be a shortcut to power. The sovereign authority of the people of Kenya rests with the people of Kenya, and the courts do not intend to interfere.
Ruto's lawyer, Katwa Kijen, who spoke to journalists after the ruling, says he is happy that the court has finally examined the case thoroughly.
The court has said that whether you are standing trial for murder or rape or crimes against humanity, your right to be presumed innocent is to apply equally to anybody else and to any other crime.
But even as they lauded the ruling, lawyer Lampa Soyinka, who was representing one of the petitioners, the International Center for Policy and Conflict, said his client will be challenging it at the Supreme Court.
Supreme Court rules are very stringent. We have only 2 weeks to go there. And the fact that we have been slapped with cost, I believe, we are likely to appeal on that particular order because public interest litigation in normal parlance does not attract costs.
The court dismissed the case, saying it was not within its jurisdiction and that the two could not be stopped to vie for the country's presidency since the ICC had not convicted them. I'm Charles Gishane for Capital FM TV.